The record. Theodore, it's okay that we're recording, right?
Yeah, no
Perfect.
problem.
Wonderful. So, welcome everyone. Thank you for joining us. We are delighted to host with us Professor Theodore Christakis, a professor of international law and European law at the University of Grenoble-Alpes and distinguished visiting scholar at the New York University Cybersecurity Center. He is a member of the Institut Universitaire de France and of French National Digital Council and a senior fellow with Cross-Border Data Forum. We are here to talk today about European digital sovereignty, and we are very eager to see what Professor Christakis has to share with us. So I'm delighted to yield the floor to you, Theodore.
Thank you very much, and thank you. And it's a real pleasure to be with you and to see once again a lot of colleagues that I have already met, to meet new colleagues. And I thank you warmly for this invitation. I know that you're a cybersecurity center and we have worked in the past. We have organized also some events together. And I'm very happy to see that you're interested in European digital sovereignty, which includes cyber, of course, but which includes plenty of other issues, which can include everything you want, after all, as we will see. And I am really delighted to exchange with you. I have prepared a presentation. I just wanted to ask you a little bit about how you wish to proceed, which is, should I make my speech and then we engage in a debate, or you want to interrupt me as it comes, whatever you wish?
It's clear that you will present peacefully whatever you have to say, and then we can open the floor for discussion.
Fantastic. So I will try not to be too long, but to give you a general overview of the issues. And I will share my screen immediately. I don't know if I have partager l'écran. Okay. So here you are. Hope that you can see my screen here. Can you confirm me? Yes. So let's start with this concept of European digital sovereignty. And I know that, a lot of persons in your center, starting with Yuval, are international lawyers. So from this point of view, the first question that I had while preparing my study on this concept was, does this term make any sense for lawyers, including for international lawyers? And what I can say for this is that from a purely normative point of view, this concept, which is so much used today, makes little sense to me, and I would like to see what you think about it, because as a matter of fact, I'm afraid, I have dived once again in the concept of sovereignty in general, in legal theory and in international law. And I'm afraid that this new concept of digital sovereignty can only accentuate the classic confusion surrounding the term sovereignty. So I went back to my basics. I opened my Lauterpact and my big writers once again. And, I counted, just reading, the big names, not the small names. I counted so many different adjectives for sovereignty in general, the classic term. I quote you some: plural, pluralistic, fluid, elusive, vague, dynamic, evolving, changing, imprecise, indeterminate, confusing, controversial, equivocal, polysemous, ambiguous, pivotal, abstract, mysterious, and so on. This was not about digital sovereignty. So if we introduce digital sovereignty, we should put a multiplier, to all these adjectives. I have not read a single person who worked on digital sovereignty and who said that this is something clear or whatever. On the contrary, everybody highlights how controversial and ambiguous the concept is. So I'm a little bit concerned that this can only accentuate, multiply the adjectives and accentuate confusion. Talking about definitions, when we use the term sovereignty in legal theory, or in general, also in science, political science, etc., because it's not just lawyers who use it, everybody's using this term. We can see that we have plenty of definitions. Some scholars in a recent writing counted 16 definitions, and I was able, to complete and to add many others. And even if you just limit yourself to the normative concept of sovereignty, there also, if you're a constitutional lawyer, you will not give the same definition as an international lawyer, and we'll have all these different debates about national popular sovereignty, internal, external, absolute, limited, unitary, divided, and all these things. So we have plenty of definitions, and the debate about sovereignty is very difficult very often because, as a matter of fact, sometimes people debate and they don't debate on the basis of the same definition. We can only debate if we have a common intellectual framework. And very often this is not the case. If you read Don Herzog's recent Sovereignty, Rest in Peace, RIP, book where he promises to bury once for all. I have heard so many people, read so many people who are promising to bury the concept of sovereignty. You see that, his definition is not entirely the same as ours, as international lawyers. And from this point of view, I'm a little bit concerned that, we had all these controversies in the field of legal theory concerning sovereignty, and we can only have more controversies now that we use new terms such as digital sovereignty. But somehow also, it's interesting, that I entirely agree with what Louis Henking once famously wrote, that sovereignty is often a catchword, a substitute for thinking and precision. It's exactly what is going on with the concept of digital sovereignty. We should just accept that this is not a legal concept, digital sovereignty. It's just, from a political point of view, it's an extremely powerful concept, which is precisely, it's broad and ambiguous enough in order to encompass very different things and to become a projection surface for a wide variety of political demands. I was in the other panel, the Hague Cyber Norms panel before joining you, and one of the two questions was, can we bring some conceptual clarity? And I said, no, because the very objective of digital sovereignty is not to be clear. This is the objective. Now, of course, all this is not satisfactory for our discussion, because if we focus as international lawyers in the concept of sovereignty, I think that we should all agree what we're talking about. We know that sovereignty in international law receives a negative definition, contrary to a constitutional lawyer who will define sovereignty positively as the summa potestas, the supreme power of the state, which can put in place the legislative, executive, jurisdictional power. In international law, we all know that we define sovereignty in a negative way as the absence of a superior power to states, the non-submission to a higher authority, what Anzilotti said in 1931, that the state has over it no other authority than that of international law. And this is the result of this is the equal sovereignty of states. States might be big or small, powerful economically and militarily or not, weak or developing, but they are all sovereign. And despite the de facto huge disparities of powers between states, they are all considered sovereign from a normative point of view. And this is something very useful. I think that this is a very useful fiction for the construction of international law. And from this point of view, if you take the concept, let me enter into the concept of digital sovereignty, which was a little bit initiated in France by writings by some people who are talking about the digital colonialism, that Europe is colonized by the GAFAM, by the Americans, and things like that. I mean, if you take this concept of digital sovereignty, as meaning, this is how they interpret this term, the people who use it, that if a state has not yet achieved strategic autonomy in the technological sector, then it is not sovereign, it's colonized. I mean, this makes no sense in international law. We will destroy everything in international law. The result of transposing such a political idea to the normative field would be that only the United States, and eventually China, but I doubt about China, but only the United States will be the only sovereign among the 193 UN member states, which is entirely absurd, contrary to the UN Charter, and entirely inaccurate from a legal point of view. So let's forget eventually all this, or let's just keep it on the background, and let's try to understand how this concept of digital sovereignty is used. And in my paper, in my study precisely, and I read all the people who wrote seriously about digital sovereignty and all the declarations of the European Union, because every politician today, in Europe, when Jean-Claude Juncker, who was then president of the European Commission, said just 2.5 years ago that the hour of European sovereignty has come, half of Europe criticized him. But times they are changing. Today, all politicians in Europe talk every day about digital sovereignty. You see this in the big declarations of the European Council all the time. We use this term. And so I wonder, how is this term used? Well, the term is used in two ways. The first way is to try to use this term as meaning that sovereignty as regulatory power. And this will be the first part of my presentation here, the regulatory power, which means that, often a lot of people who write in newspapers or political discourses say, oh, Europe is not sovereign digitally because, for instance, we cannot regulate the GAFAM. We cannot regulate the big tech. Or there are problems. We were unable to install a digital tax or things like that. So the first concept is regulatory power, the power to regulate. This is the first understanding of digital sovereignty. And the second, to which I will come later, is strategic autonomy, which means that, as the European Council said, that Europe should be able to make autonomous technological choices and develop and deploy strategic digital capacities and infrastructure without being dependent to China, to the United States or others. So let's examine and let's give some highlights about these two possible understandings of sovereignty. So the first understanding is regulatory power, and there I was really surprised with what I found in the different writings. I cannot count the numbers of Tribune in Le Monde newspaper in France, where people say that Europe is weak. We have, of course, adopted the GDPR, the General Data Protection Regulation, but we are unable to regulate big tech, and we're unable to install a big digital tax, and we are dependent on, for instance, the extraterritoriality of US laws such as the Cloud Act, or things like that. And as a matter of fact, this is a big surprise, because if there is one champion in the field of regulation, this is Europe. And it's not just about internal regulation. In my study, I use widely the concept of the Brussels effect, which was elaborated by Anne Bradford. You might have read her great book about the Brussels effect, where she shows precisely how Europe is able not only to regulate several important things in Europe, including the digital sphere, but also how this regulation becomes the global standard. We have a kind of Europeanization of international law, as we call it, where we have a huge impact of European rules. we can find this in other fields. You can read the Anne Bradford's book in the environmental sphere, for instance. More generally in human rights, who can deny the huge influence of the European Convention of Human Rights, for instance, and the case law of the European Court of Human Rights. We all know that when the ICCPR, the International Covenant on Civil and Political Rights, was drafted, they did a lot of copy and paste from the European Convention, and same things, I think, for the American Convention on Human Rights, etc. So this is true in several fields, but this is also entirely true in the digital sphere, where we see a very huge influence of European norms, and not only the GDPR. You know, sometimes in these op-eds, writers who want to speak about how weak Europe is, etc., they say, of course, with the exception of the GDPR. I mean, what a huge exception. If only it was about the General Data Protection Regulation, we should say that today, between the previous directive, the predecessor of the GDPR on data protection, protection of personal data, and the GDPR, there are almost 120 countries who have followed Europe in the field of personal data protection, which is absolutely amazing. And this is something that we should definitely highlight and try to understand, because you know that the GDPR, for instance, there was a huge lobby by big tech, etc., against the GDPR, but there are a lot of reasons why we have this influence in this field or in the other fields that I will immediately mention, including, and this is very weird, because, you know, especially in France and in other countries, we have this discourse against the big tech, the GAFAM, but it's very weird how the big tech and the GAFAM become the best allies for the EU sometimes in order to promote some rules for several reasons. And very often, I don't want to present them as angels, far from there, but very often after lobbying hard against instruments such as the GDPR, finally, for one reason or another, big tech understand that probably this is the best option. For instance, one of the reasons is that Europe has a very big market. So they will need to comply with the GDPR, with the standard. For instance, they will need to implement privacy by design when they develop a smartphone like Apple or whoever. And from this point of view, if they develop software, etc., for the smartphone, privacy by design, it will be much more interesting economically to do this privacy by design all over the world, instead of having different models of software, different software in Europe and different software in the United States and different software in Israel and different software in India. So from this point of view, we have what we see in the environmental law field, which is that very often if you want to commercialize a product, including software or other things, you will set privacy, for instance, by default all over the world. You saw what happened recently when WhatsApp suddenly said that they will change their privacy policies for countries other than Europe, and there was a revolution, you know, against WhatsApp, because everybody expects that the European standards will be followed all over the world. So from this point of view, I think that this is something interesting. And not only this, but also very often some companies, you might have followed the debate concerning Apple, for instance, and the new privacy politics, etc., which often also creates some clashes, like in this case with Facebook. Well, some companies like Apple, like Microsoft, for instance, you know, they try to play the privacy argument as a commercial argument. You know, if you buy our products, you will be protected. We'll speak about what Microsoft has done, plenty of things, including a lot of legal challenges against the US government for surveillance issues, etc. New policies. Apple is doing the same thing. So very often it is presented in one way or another as the high moral standard, as the best option to follow the European rules. And this is not just about the GDPR. It's the same thing. I mean, it's not only about hard rules also. We have other rules, hard rules, regulations and directives have been followed. We have plenty of legislative proposals who will exercise a huge influence worldwide, like the Digital Government Act, the Digital Services Act, the Digital Market Act, which are about regulation of platforms, including fight against hate speech and illegal speech online. And all this will exercise a huge influence at the world level. We have the new AI regulation, which was proposed by the Commission just a few weeks ago, and will also have a big influence at the universal level. So it's about hard rules, but it's also about soft law. We have, for instance, it's very interesting to see the huge influence of soft law, such as the European Code of Conduct on countering illegal hate speech online, which has been signed by all big platforms and followed and influenced their policies, and influenced also the policies of other states. The Code of Practice on Disinformation, which was introduced by the Commission in September 2018. And we see that not only tech is following this, but also other states, which for one reason or another, when California adopts its privacy law, for instance, by following the GDPR, this is extremely significant, and other states in the United States, and we're talking about a federal law. So why? Because there might be the activists will use these European rules in order to push for the adoption domestically, or some states might find it as being the best option politically or morally. So we can see this also with the influence of the case law of the Court of Justice of the European Union. When the Court of Justice of the European Union sneezes in the digital sphere, the whole planet catches a cold. Immediately after a Schrems II judgment in July, the Israeli Data Protection Authority immediately, in the next few days, said that we should follow the standards of this in relation with external transfers, etc. Same thing for the Swiss Data Protection Authority. And we see what a huge influence judgments like this one or other judgments are playing in the field of data protection or competition law or in other fields. And same thing for the position of the data protection authorities in Europe. So from this point of view, we have a huge influence of a huge regulatory power of the EU, which also has some limits. And these limits, you have to understand them, and I try to analyze them in my study. There are internal limits. Sometimes, for instance, some European countries cannot agree. We have seen this with the digital tax debate. For instance, there were a lot of disagreements, but also sometimes we have some limits of EU law. One of the limits that will be of particular interest for you as a cyber center concerns precisely the politics on cybersecurity, including protection of critical infrastructure. What we have seen about the Huawei debate, for instance, was that it was very difficult to come with binding common European policy concerning 5G and the exclusion of Huawei in Europe. Why? Because national security is not a competence of the EU. We have a clear limit in the treaties, Article 4, Paragraph 2 of the Treaty of the European Union, which says that national security remains the sole responsibility of each member state. And from this point of view, you understand that it is a little bit difficult, and we see this in other fields, but in the 5G debate, we have seen the difficulties of coming together with a common policy, despite the development of a toolbox, etc. And despite the fact that, after all, there was a lot of work of the European Union, we see more and more an erosion also in other fields of the national security exemption in European law in order to be able to deal with cyber security issues and protection of critical infrastructure. But nonetheless, this is a limit, and we see this in other fields concerning, for instance, the debates concerning attribution of cyber attacks. France said several times that this should remain a national prerogative. and others. So we understand from this point of view that we have some internal limits and then we have some external limits. When it comes, for instance, the whole debate about access to digital evidence and the issues such as conflicts of laws created either by the extraterritorial effect of other states' laws, such as the Cloud Act, which says that, for instance, if the European Department of Justice makes a request to a US cloud provider for data stored in Europe, then the cloud service provider should give this data irrespective of whether the personal data in question are European personal data stored in Europe of a person that never left Europe. And this is in conflict with the GDPR. But inversely, the European Union is trying to do exactly the same thing with the e-evidence legislative proposal of a regulation, which says exactly the same thing, even if the data are stored in the US. And there is the Stored Communication Act clearly prohibits a US cloud provider to give data to a foreign power. So we'll have conflicts of laws of this kind. And we all know we are international lawyers. We know what is the solution to this. The solution to this is to use international law tools in order to resolve this conflict of laws. So we need international law very often. We need it also in the field of the digital tax. And this is why we have all this process in the OECD. And this is how we regulate in some fields. It's not just, I do whatever I want, because if it affects the rights of other states, if it creates conflicts of laws, then this will create problems. And this can hinder an effective regulation. So I will move now immediately to the second, just a final conclusion concerning this first part. I think it's interesting for international lawyers. There was a lot of criticism also concerning this fact. Some people said, yeah, great, true. The EU exercises a huge regulatory power, but referees do not win. We can regulate personal data, cross-border data transfers, artificial intelligence, and all the other things. But this is not how we're going to become autonomous strategically. For instance, this could hinder innovation. And there is a huge debate in Europe, for instance, how far this new regulation of proposed regulation of artificial intelligence should go. This is true. And from this point of view, it's clear that this regulatory power should not be the only thing in the debate about digital sovereignty. We definitely need the second part that I will present immediately, which is the part concerning the development of strategic autonomy. But nonetheless, Europe should not underestimate the fact that there is a giant struggle going on for regulatory dominance internationally. And we see this with many attempts also by the United States to do things in the digital sphere, etc. And Europe has a big advantage in this field, not only because of its past legacy and continuous lead, but also because its values and its vision often appear socially desirable at the international level. They are followed by the NGOs, by civil society, and they are followed by big tech, as I said, as the best option very often, or for other reasons. And from this point of view, Europe has often appeared as the third model. Between an erratic America, we come out of the Trump years, for instance, with this idea of America first, etc., not multilateralism. I will come back to this immediately. And an undemocratic China, for instance, Europe appears as the best option. And from this point of view, this is why I say in my study that we should be very, very careful to not to harm this big advantage, this high moral standard also of European regulation based on human rights and ethical values by adopting protectionist policies. So let's move to the second part, which is the part about strategic autonomy, which is precisely this idea according to which Europe should be able to develop its own priorities, to develop its technologies in the digital sphere, and to avoid undesired dependencies. And from this point of view, what I try to show in my study is that this is perfectly legitimate. It is based on a series of legitimate concerns, starting with geopolitical concerns. And we all know that big data is the new oil, that high-end microchips are the new strategic assets, 5G telecommunications, the new strategic roads, quantum computers, the new nuclear submarines, and whoever runs the global Internet of Things, connecting billions of devices, excelling in using artificial intelligence, we have a huge geostrategic advantage. And Europe often feels that it has been left behind on these issues, and that there are a lot of dependencies that I will analyze in a few moments. And also Europe is watching what's going on between the US and China, especially during the Trump years, but this will not change, of course, with the Biden administration. Is very much bipartisan. The fact that we are entering in a kind of Cold War 2.0, and we have all these actions taken by the United States against China, accusing China of several things. The Trump administration developed the Clean Network program, for instance, where they want to exclude China's intrusion and influence in a series of things, like applications downloaded in smartphones, any kind of fear of intelligence gathering in the cables, in the oceanic undersea cables, a clean cloud also, avoid any kind of intrusion of Chinese authorities in the cloud, etc., etc. So from this point of view, I've seen all the things that have happened with the desire to ban some apps such as TikTok or WeChat, to blacklist microchip semiconductor Chinese companies, Huawei, of course, and many other Chinese companies. So Europe is seeing all this, and Thierry Breton, for instance, said Europe must now take its strategic interest into its own hands in order to ensure sovereignty, which has this has become a real necessity. And Europe understands that it has a lot of dependencies. If we see a little bit the numbers, we'll see that less than 4% of the market capitalization of the world's 70 largest platforms is European, while 73% is American and 18% is Chinese. In the microprocessor sector, which is absolutely strategic, we see that we have some European companies, but they're not in the high-end part of the global semiconductor market, but in the low end. And this is a dire example of Europe's dependency on foreign companies. We see in artificial intelligence also countries like Israel were extremely reactive and active in the field, for instance, of artificial intelligence, less in Europe, despite the assets that we have. So we have all these dependencies, which became only even more important with the effect of the COVID-19 crisis. There were a lot of debates, for instance, in Europe concerning the fact that we had to use Zoom like today, or Teams, etc., because European video conferences platforms were not working properly. Or we had huge debates concerning the contact tracing applications. France wanted, for instance, to develop its own contact tracing application, and Apple and Google imposed limits to this. And France was very frustrated for several reasons that I will not analyze here, but France was very frustrated being dependent on the almost monopoly of the market of smartphones, software by Apple and Android and Google devices. So from this point of view, we can understand this. There are a lot of opportunities that can analyze. And from this point of view, this is something positive, this political concept of European digital sovereignty. A lot of actions have been taken to develop quantum computing, to develop cloud computing in Europe, to develop high-end microchips. In the field of cybersecurity, we're about to revise also the NIS directive right now. In the field of artificial intelligence, there are a lot of things going on. And from this point of view, this is something positive. But, and this will be the last part of my presentation, but I would say last but not least, this quest for strategic autonomy entails a lot of pitfalls, at least 4 pitfalls that I analyze in my study. And I think that this could give place to fascinating debates. The first pitfall is the risk of creeping protectionism. What we see in Europe is that we have very often a lot of discourses which are almost openly protectionist. Like, for instance, there are a lot of representatives of European industries, for instance, who are calling for using public procurement only for European companies. And giving, for instance, I don't know, China, or in some instances, the United States as an example, without proving, by the way, that this is the case, really the case in the United States, or to give subsidies, massive subsidies to European companies in order to develop, or to exclude European companies, for instance, when it comes to the Digital Markets Act, which creates a new category of gatekeepers for big platforms. They said, yeah, but this should apply only to US and Chinese and other platforms. It should not apply to Booking.com, for instance, despite the fact that it meets entirely the criteria to be included. So I do not say necessarily, I have to be clear that I do not say necessarily that protectionist is a bad thing. This is, a political debate. I'm only saying that before engaging in open protectionist policies, Europe should examine the risks posed by such measures. And the risks are very important, and we as international lawyers know them. First, a big risk of violating international law, for instance, World Trade Organization standards. But this is a big debate about the fact that there is some delay in the World Trade Organization in dealing with digital issues. Nonetheless, what we hear here in France and all the time is that we have to develop the Airbus of the digital sphere, and implying that we need to give huge subsidies to European digital companies so that they will become, as Airbus became, thanks to subsidies and other measures. There are a lot of limits for me to this argument. I just mentioned it, including the fact that, as you know, Europe has been condemned by the World Trade Organization a few months ago, which also authorized the US to adopt $7.5 billion in tariffs against the EU for this protectionist and contrary to international commercial law measures. The US also, by the way, was condemned for the subsidies to Boeing. Another issue for international law is that if other states will retaliate very, very probably. LVMH, the Lux exports all over the world, etc. So it's another issue that I analyze extensively is the issue of data localization. I hope that we'll be able to come back. I have written extensively on the issue of data protection, and we see in France more and more calls, and in Europe, for data localization, for localizing all the data in Europe. And this is something new because Europe has always been against protectionism, but also against data localization. for several reasons, considering that it is absolutely essential for international commerce to have international data flows and not to localize them. And especially you understand that if everybody localizes data, then this will be a huge problem. If it's only one country that localizes, probably this won't be a huge problem for international commerce transactions. But if everybody is doing this, and everybody, well, India is trying to do it, China, Turkey, Indonesia, Vietnam, etc. So this will be a very huge problem. And if you read Recital 101 of the GDPR, you will see that the DNA of data protection in Europe has always been that has not been that we should localize data, that data should not travel out of Europe, but the DNA of the GDPR has always been that data should travel, but with protections. And from this point of view, the Recital 101 says flows of personal data to and from countries outside the Union are necessary for the expansion of international trade and international cooperation. So the huge debate right now in Europe, and probably we might come back because I would like to end in 3 minutes from now my presentation and open the debate. But I have written extensively on this issue, which is how can we make the distinction between protection, data protection, and data protectionism? Data localization, for instance, might be the only solution in some cases. If there is no other solution to protect data, well, eventually the only solution remaining would be to localize everything in Europe, to impose any kind huge prohibitions of any data transfer, etc. But what would be the cost of this? This is the big question. So this should be done only if it is absolutely necessary. We should apply a necessity and proportionality test, and we should also try to see if there are alternative solutions, because there are a lot of criticism that we can formulate against data localization, including cybersecurity risks. What happened during the COVID crisis, for instance, is that several towns in France, which have been storing data, Marseille town, for instance, have been storing data locally in a server, not using a cloud service provider, have been attacked by ransomware and had to pay huge amounts of money. Their backup was in the same server. And you understand that from a cybersecurity point of view, it might be much better using a cloud provider with backups elsewhere in the world so that you will not lose your data. Huge economic cost eventually for European companies. Risk of policy inconsistencies, because Europe has always been extremely critical of data localization, and a lot of human rights risk, not for Europe. Europe will not start doing data localization like Russia tries to do it. But what would be the message sent to all these regimes who are trying to localize data so that we'll be able to always have access to what the dissident said, etc., or wrote, and in order to be able to persecute them? So this is a very big issue. A third issue is what kind of model Europe wants to promote. Thierry Breton said a few months ago about data localization, the Chinese and the Russians are doing it, so we will do it too. So I wonder in my study if this is a good idea. Europe has always been presented as a third model of the digital world between the laissez-faire, laissez-passer attitude of the Silicon Valley and the Chinese model of the surveillance state. Well, Europe has always presented a third way of doing things based on, as I said earlier, on human rights, on data protection, on protection of privacy. So if we enter into this logic of following the Chinese, how is this going to end? Is it a good thing for Europe to become more Chinese? I doubt it. Europe has always been extremely critical of the methods used by the Chinese in order to become a big digital power. Protectionism, theft of intellectual property, surveillance, firewalls. Europe has always condemned all these things, and it could be extremely tricky now to enter into a logic of following China. And finally, the last thing, we see these discourses of picking up champions, of trying to create the Airbus, as I said, in the digital sphere. There are also a lot of risks. We have a very poor track record in France, for instance, for picking up champions. I can give you just two examples. Several years ago, the government gave a lot of taxpayers' money in order to develop a competitor to Google search engine called Quaro. Have you heard about Quaro? No, isn't it? And today, in order to understand what was Quaro, you have to Google Quaro. And the fact that you have to Google Quaro instead of querying Quaro in order to understand what it is shows how bad it ended, isn't it? That it didn't fare very well. And same thing when France gave a lot of taxpayer money in order to create a sovereign cloud a few years ago, it also ended very bad. And more generally, we should be careful about this because it includes a lot of risks also and pitfalls, and other states might do the same thing. So I will end my presentation by saying that, as a matter of fact, this concept of European digital sovereignty as a political concept is something I find useful, powerful, that we should not forget, nonetheless, that the concept of sovereignty, digital sovereignty, was first used by authoritarian regimes in international law. We know very well that it started with China, with Russia, which adopted in 2019 law on digital sovereignty, etc. And from this point of view, it is pretty ambiguous, and it can be used in a powerful way in order to promote some good things. But at the same time, I think it's very important to think very carefully about this in order to avoid the pitfalls, in order to avoid the risks also for international law, and to be able to maintain this European third model of the internet, which is based on human rights, data protection, protection of privacy, and freedom of speech and other values. Thank you very much. And I will put an end here to the sharing of my screen, and I'm entirely at your disposal for the debate.
Thank you very much, Theodore. We will open now the floor for questions and comments. If I may kick off the discussion with a comment and a question. So first of all, you begin with a description or the definition of the concept of sovereignty, either from a political or a legal point of view. In my view, sovereignty is best manifested in the fact that international law is state-centered, and as such, it safeguards state sovereignty. Now, throughout the years, we've seen several challenges before the principle of sovereignty: the rise of international organizations, terror, etc., etc. But at the end of the day, sovereignty proved very resilient. Now the question emerges: what is it in the digital sphere that is different in its nature or in its characteristics and might bring about a different result in comparison to other challenges? In my view, which is very limited, for a real change to occur, I think that the question is whether an entity can develop certain independence from states. So if we look at international organizations, they ultimately rely on cooperations of states. And if you look at terror groups, we know that their biggest challenge at the end of the day is they don't have any territory to build and to build on, because it's already occupied by states. But on the other hand, the example you gave about France and Apple is worrying in this regard. It actually shows that the challenge is bigger than the ones sovereignty faced before. Now, a more specific question is, do you think that the influence of Europe will mostly be in the field of human rights, like the right to privacy, which you mentioned? Because it's a field where it is already a champion and it has been leading for years? Or can we really generalize or conclude that the fact of Europe will be more widespread? If so, I'm curious to know where and how, because at the end of the day, you mentioned that through interaction, Europe will impact. But how many states which are non-Western can really offer software to Europe, which it doesn't already have, putting Google aside? And out of those states, non-Western states, how much of them are not already following Europe in the sense of human rights, democracy, and etc. And finally, in relation to the pitfalls, I think that the pitfall of protectionism is the biggest risk in relation to the issues I raised, because Europe is always the moral voice against nationalism, against protectionism. So if Europe will begin with protectionism, then the EU dream is proved as an illusion. Thank you very much.
Thank you very much. And I will try. You raised a lot of issues. Most of them are observations to which I do not need to respond. Just 2 or 3 highlights, but I think that this will come back also during the debates. You're entirely right in your analysis of sovereignty and the idea of, well, we have always conceived this international law state-centered, and suddenly what are the challenges? And one of the main issues, which also explain why you use this term sovereignty in this field, is precisely the idea that, you know, the internet, what is cyber, is borderless. You remember Barlow's Declaration of Independence of cyberspace, where he said to states, you have no sovereignty where we gather. And we all know that in reality, we are no longer in the cyber libertarian dream. A lot of states did a lot of things, including adopting laws. It started with China, with the Great Firewall of China. As I said, Russia with sovereign internet law. It started with these authoritarian regimes who tried a little bit, you know, to get a grasp of this cyberspace in one way or another in order to promote their interests, including the idea of controlling expression, you know, limiting freedom of expression, identifying persons, you know, surveillance, avoiding information coming in. It's interesting because we're talking about data localization. China, at the beginning, when they were not doing data localization, their big concern was to avoid information coming into China. So this is the Great Firewall, while data localization is about information not getting out of a specific country. So from this point of view, I think that there are a lot of really interesting issues to debate. If you see reaction to cyber attacks, you see that a company like Microsoft is doing far more than, you know, many more states, and has the much more powers to do things in reaction to cyber attacks than a nation state, for instance, most of the states in any way. So nobody doubts the fact that we have challenges, that we have a tremendous power concentrated upon some big tech companies. But nonetheless, the proof that the classical concept of sovereignty as we understand it in international law is still perfectly valid is the fact that states regulate all this big tech, regulate them very heavily, despite lobbying, huge lobbying, all the means that they're using. Well, this the best proof, you know, the GDPR is one of the best proofs of what is going on. So, of course, Facebook can create its oversight board, which exercises a huge influence, but this does not create an obstacle to, I don't know, to Trump going to a US tribunal, saying, you know, that they have violated my freedom of speech, for instance, you know, the Fourth Amendment or whatever. So from this point of view, I think that we should remain very careful not to make a confusion between the de facto power, which already exists in international law. We have huge disparities of powers between states, and this does not challenge, as I said before, our normative understanding of sovereignty, for me at least. So this exists. We have all these challenges. We have all these new phenomena, but still, I think that states have the control, have the possibility to adopt tools, either domestic regulations, laws, etc., or to adopt international law instruments, which are extremely important, which have been neglected. We don't have a lot of international law instruments yet. We have the Cybercrime Convention. We're discussing a new protocol, the Cybercrime Convention. We have other, but we desperately need international law in this field. And when you're talking about European influence in other fields, that the GDPR, the privacy, let's give the example of the digital tax. It started with all this pressure by the European Union, and now we're about to conclude an instrument of the OECD about this. When it comes to surveillance, the OECD, can you imagine the OECD is talking about surveillance and cyber espionage? I would have never imagined this. The OECD always had a very approach which was based on companies, economic development, etc. Their role was extremely reluctant to talk about issues that touch about national security. When they created 1.5 years ago this body to discuss cybersecurity at the OECD and hackback and things like that, they didn't name it cybersecurity body. They named it digital Security for Prosperity Forum. Okay, in order to vote, because if they have put cybersecurity, everybody will have put his veto. So when you see these developments, you see that it is very interesting. We need international law to have more and more initiatives. And I do think that the influence of Europe in several fields, regulation of platforms, for instance, this concept of the gatekeeper, all these things could be extremely influential also. Eventually, not on all fields. I would be very interested, it will be very interesting to follow the debate about the regulation of artificial intelligence, for instance, but still there will be some influence and some kind of Brussels effect in this field also.
Thank you very much. So would you prefer that we will take 2 questions at a time from 2 people? Yeah. Okay, so our next 2 questions will come from Yuval Shani, the director of the program, and from Advocate Amit Ashkenazi, which is the legal counsel of the Israel National Directorate for Cyber. Please, Yuval.
Yes, hi Theodore, good seeing you. I mean, you've been very prolific recently. You've been writing more quickly than I've been able to read, so that's very impressive. So thank you for joining us and congratulations for all the wonderful work. The prosperity thing, of course, reminds Israelis that we had the Trump plan was called Peace to Prosperity. So I guess a lot of odious agendas have the prosperity attached to them. So, more seriously, I have 3 very quick questions for you. One is, I know I wrote Tal only 2, but I thought of another one when listening to you. One is the issue of, sovereignty always had a positive, but also a negative component. And that was the principle of non-intervention at some level or the other. And the question is, do you see this component also play out in digital sovereignty? Although I accept it's not a legal concept, but it is influenced by thinking about sovereignty. So that's one area. What does it imply for other actors in terms of operating within the digital sphere of another country? Secondly, you presented this as an attempt by Europe to reestablish its authority vis-a-vis other superpowers. Okay, the Americans, the Chinese, maybe the Russians. But perhaps the story is really about states trying to reassert themselves vis-a-vis technology. Okay, so clouds, of course, present, as you've written, serious issues for states in terms of digital evidence. And Bitcoin or more blockchain more generally presents a very serious problem for states in terms of regulating economic activity. So maybe this idea is really an attempt not just to push back against states, but also to push back against technology. And the question, of course, whether the genie is not already out of the bottle, whether this is possible. And just a brief observation, I think the Brussels effect, I think there has to be perhaps more thinking about what does the Brussels effect does to global development. And I think that when one is introducing high standards for privacy or AI regulation, etc., this is going to have it's already having, but it's going to have in the future, much more serious effect on data transfers and technologies transfers to the global south. And I'm not sure that, correct me if I'm wrong, but I'm not sure it's really part and parcel of the EU discourse at this point in time.
Thank you, Yuval. Advocate Ashkenazi, please.
Hi, thank you. I will echo Yuval almost completely, which is quite unique, but maybe this is because of my academic moonlighting. So thank you very much for the for the talk and your prolific writing, which we enjoy completely. I have two quick questions which continue some of Yuval's themes. The first thing is, from a public international law point of view, how do you look at this, I would say, data localization discussion? Because we know in the GATT agreements, we have exemptions for data protection regulation. They are exempt from scrutiny as illegal trade measures. I'm talking very shorthand here. And these new measures coming from the EU, which are, as you very correctly sort of assessed, they are more third pillar type of stuff. They're security, but they're under an economic grounding, an economic setup. How do you see this? Is the EU checking the boundaries of what it can do for actually strategic stuff, which is maybe illegal from a trade point of view under an economic regime? And of course, I'm speaking very broadly just to see what you think about it. And the other thing is, what you would react regarding the Microsoft statement that it is heeding to the call of the Europeans, and I mean, how would you analyze this within this very fascinating framework that you presented? Thank you.
Well, thank you so much to both for these fantastic questions. I will try to address them briefly. First question by Yuval about precisely one of the things that I wanted to do in my study, but I refrained from doing this, was because it was only 110 pages, was to try to explain that all this use of the term digital sovereignty by Europe has almost nothing to do, it's very weird, with the classical discussions that we have in international law in the field of cybersecurity about sovereignty and about non-intervention, about non-interference, about whether, for instance, a cyber attack or an action would be a violation of the sovereignty of other state, and we'll have all these debates about whether the rule is a principle of sovereignty as such, or if it is in reality, the non-interference or the non-intervention rule that derives from it. So we have all these debates, but these have almost nothing to do with the use of the term digital, for the time being at least, because as I said once again, digital sovereignty is used much more at the European level, and if you see also the definitions given by the European Council as a term in order to promote the idea of strategic autonomy or the regulatory power of Europe, etc. So I think that this is, I don't want to say in any way that, Europe has done a lot of things. They have developed the cyber diplomacy toolbox, which has been updated very recently in order to include a common reaction to cyber attacks and using, the mutual defense clauses in the treaties, etc. All these things. But this is done a little bit in parallel with the debate about digital sovereignty. So I don't think that Europe felt the need to mobilize, let's say, to use this new term in order to introduce something new in the debate about non-intervention, etc. They're doing this in other spheres, the fight against disinformation, the fight against electoral interference, etc. But it's not linked, for the time being at least, to the use of the term European digital sovereignty. This was the first point. The second point about the fact that states try to reassert their powers towards big tech, entirely agree. This is the whole point, how it started, this term of European digital sovereignty, once again. But precisely, I don't think why we need it. Nobody doubts about the regulatory power of the European Union towards big tech. There is no place other like in Brussels for lobbying against or in favor of every single legal instrument that comes out from Brussels, either hard law instrument or soft law instrument, has been preceded by a tremendous lobbying, by all kinds of lobbies that you can imagine. When you take the recent copyright directive, for instance, there was a monumental, a giant, I have never seen such a lobby, such a fight of lobbies between, on the one hand, civil society with a big tech, they were allies for once, and on the other hand, all the different editors, media, etc., who have been successful in beating the civil society and the big tech lobby. So, of course, we have all these phenomena, and it's not, when we're talking about regulation, let's not be naive, because we know how it happens in Brussels, and we all know also that the big tech sometimes is pushing for some kind of regulation, trying to scale it down. When you hear calls in the UN, in the US, for instance, let's do a privacy federal law, or let's regulate artificial intelligence, sometimes you must think that, you know, the idea behind is that we're going to lobby and we're going to have low standards, so this will be very good for us, for the industry. And we also see this in the current debate about the regulation of artificial intelligence. And for the time being, the tech has been pretty successful concerning the regulation proposed by the EU in saying that we should not hinder innovation, for instance. So we do have all this, but I still maintain that states have the control and states can regulate, and that states are the only ones who are, let's say, sovereign from a normative point of view. I will not react to your third question, Yuval, because it was much more an observation than a question. But I will definitely answer to Amit's first question, which is extremely important. You said, do you think that the EU is trying to test the limits of GATT or commercial law? I think that we should understand that the EU is not a monolithic thing here. When you see all this debate about data protectionism and trying to test the limits, in reality, even in the European Commission, there is a big fight. There is a big internal fight on all these issues in the European Commission. If you see the European Commission, for instance, you will see that there are some commissioners and some commissioners, some people who are very much in favor of the old European attitude of openness, free commercial flows with protection, but against protectionism, in favor of data protection, but reasonable data protection and things like that. And then you have other people who might, even including the Commission, have a much more protectionist attitude. And every single instrument that comes out from the Commission is the product of a big fight. If you see, I will just give you an example, the Data Governance Act. The Data Governance Act was published last November after a huge fight within the Commission, and there was a previous draft which was openly, clearly going against World Trade Organization law, against GATT law. So they realized this. There were a lot of reservations from several commissioners on this, and finally, the act that has been published was a big change in relation with the previous draft in order to address these issues. And it contemplates a very complicated mechanism which raises some issues, but it was not the open protectionist thing. And it's very important because the Data Governance Act is about protection of non-personal data. And the idea was to create, of the initial draft, was to create a regime for non-personal data, which was, from some points of view, even more restrictive than the GDPR about personal data, which was something really big. So it's one thing to say, yes, we will organize, because Europe has a big power, which is all this data that we have in the health sector, in the industry sector, and we want to create all these data hubs where we will share this data and use artificial intelligence in order to invent the next big things in this field. This is very legitimate, and it's also legitimate to say, let's protect this data from the kind of intellectual property theft done by the Chinese or access by foreign powers. All this is perfectly legitimate. But when you see in a draft like this that we can only use cloud providers who are not subject to a foreign jurisdiction, you say, hey, just a sec, this is not how it works. because afterwards the American or the Chinese will say exactly the same thing, exclude European companies. So the best way is to find ways to have protection, which is absolutely legitimate, without entering into not only protectionism, but what could be a sterile attitude, because if you cannot use the tools offered by AWS, by Microsoft, etc., in cloud computing, then you will not be able to invent the next big thing, and the others will, Israel will use it and will, this is the big problem, also a big challenge. This could kick back. And your second question was about the Microsoft statement. Well, there were several Microsoft statements. Companies try to adapt to the circumstances. They're doing a lot of things. And these companies, it's amazing. They have fantastic lawyers, really great lawyers. The litigation that Microsoft is doing in all these fields, data protection, cybersecurity issues, hackback, things like that, it's absolutely amazing. So Microsoft, all these US cloud providers are found in a situation where you have, on the one hand, Schrems II judgment, which invalidated Privacy Shield. On the other hand, you have the European Data Protection Board, which came out, we're all waiting for this last November, and they came out with an extremely restrictive guidance, while the Court of Justice in Schrems II left open some windows, at least, for international data transfers. The European Data Protection Board came and entirely closed these windows in all cases without adopting a risk-based approach, just saying that even if there is a very remote risk of access, then you should not use a US provider. So they try to adapt to this while waiting for this, for the successor of the Privacy Shield. And let's hope that this will come sooner rather than later. And so Microsoft came out first by saying that the first comment was, we will challenge any kind of demand of access to European data by a foreign country when you have the possibility to do so. For me, this was huge. Schrems said, it's nothing, it's self-evident. It's not self-evident at all. You remember the Microsoft Ireland case in the US Supreme Court in 2018. Well, you have a multiplication of cases like this, and they will challenge everything. And you would say that, sometimes you might not need to challenge, but this is the only way to say that we adopt legal safeguards which are extremely strong. We will challenge everything, we will create precedents, and we'll show that the legal safeguards work. And then they came with a second announcement a few days ago and say that we will store and process all EU data in the EU. This is like a response to Thierry Breton, when he said the Russians and the Chinese are doing it. I have always said that European data must be stored and processed in Europe. Well, this is what they're saying, and they try to adapt to the circumstances. Google is making alliances with European cloud providers, and Microsoft last week did the same thing, an alliance with two European French companies, Orange and Capgemini, in order to create a sovereign cloud. So you will have US companies who are doing sovereign cloud for France, using all kinds of legal and technical safeguards to make sure that no country in the world will be able to access the data without an agreement by France. What is the answer to this? Well, they try to adapt. It's logical. This is their business. This is what they're trying to do. The answer is use international law tools instead. Let's create trust. We have all this process going on in the OECD. We have all this. I definitely think that this is a big moment for democracies around the world. OECD, starting with the OECD, like-minded countries, to try to establish some good standards in this field, and then to move to international law solutions, also treaties like the one which is negotiated between the EU and the US on access to electronic evidence right now. So we need all these tools, and I think that we have plenty of work to do as international lawyers in the coming years.
Thank you very much, Theodore. As time is running short, we will move now to 3 questions in a row, or three people who will raise a question. The first one will be Lon Jesper from Tel Aviv University. The second one will be Tomer Shadmi from the Federman Cybersecurity Center. And the third one will be from Dana Yaffe, which is from the clinics division of the Hebrew University, and which instructed the human rights, digital rights clinic. I'm sorry. So please, Alon, begin.
Hi, thank you, Theodore. It was really, really great talk, really illuminating. And I have two short questions. The first, I would really appreciate if you could talk a bit more about the relations between digital sovereignty of Europe and digital sovereignty in Europe, because you're in the talk. There's a move a few times from the EU level to a country-specific level, and then we go back to the biggest countries and the strongest countries in Europe, like France. And the question is, right, what about a place like Greece? How does Greece can have a digital sovereignty that's in line with a European sovereignty? And the second thing that relates a bit to what Yuval raised early on, I really liked how you talked about digital sovereignty as a political notion that's ambiguous and broad, and is used to push all kind of moving pieces in current discussions. And then regarding innovation, I kept thinking about how we can see it in a Paulinian kind of way of the double movement of trying to slow things down until we can form meaningful institutions to balance all the kind of the different things we want to have. And that right now we use digital sovereignty that might lead to some protectionism, but that protectionism will slow things down, and that's not a bug, that's a feature of creating the space and time to have better institutions. And thank you very much.
Thank you, Alon. Tomer, please.
Yeah, thank you for your talk. I learn a lot. Thank you. And my question relates, when you spoke about localization, so one of your concern was that Europe should be like a third way between Silicon Valley way and China, Russia way. And you don't want Europe to follow their steps in data localization issues. But if we think what is this third way and what is the vision behind it, so I guess one of the important issues is democracy, and not just human right as privacy and freedom of speech, but rather democracy as a way to manage together the data and maybe to give the people the ecosystem or the structure in order to let them decide together what to do with their data and how to use it. And if you want to do this and to like have an alternative maybe to the surveillance capitalism of the Silicon Valley, then you have to do some protection to the data ecosystem and not just to the personal data itself. And then we have some experiment like in Barcelona or Amsterdam of the democratic smart city. And in a way, this is also an ecosystem of the data and not just a protection of specific personal data. That's my question.
Thank you very much, Tomer. Dana, please.
I was very similar to Alon's question.
So you waived the right.
Yeah.
Okay.
Thank you.
Thank you. Very quickly, if there are still questions, and I have talked a lot. The first issue raised by Alon, which is very interesting, digital sovereignty of Europe and digital sovereignty in Europe. Of course, when we're talking about souveraineté numérique, digital sovereignty, this is about Europe, but this could also be about France. You know, in France, when they are using the term souveraineté numérique, they're mostly using it for France, not for Europe. And precisely, you're entirely right. This a huge question, because when it comes, for instance, of creating a European Airbus in the digital sphere, you know, all these discourses, we're only thinking about you know, Airbus, it's not Greece, it's France or Germany, you know, eventually Italy, Spain. But what about all the other countries? And precisely, you know, I'm trying to be frank, although I know that it is recorded, but a lot of people using this term in France are thinking, most of all, of course, they're very interested in the European good as such, but they think that the European good will be best promoted by big French digital champions. And there was a reaction in all these things that I mentioned in my study, some reactions and policy papers, for instance, by 19 out of the 27 European countries were saying, hey, just a sec, we don't want protectionism in Europe. And, you know, they were very, very reluctant with some of the discourses in relation with digital sovereignty. Imagine if, for instance, you said, what about Greece? If we exclude, for instance, I don't know, US cloud providers, and we oblige them to use German or French cloud providers, which offer with much important cost, less effective tools, you imagine that you know, people in small countries, I don't know, Greece or Estonia or whatever, might react. And precisely one of the risks that I raise in my paper is that we should be very careful of this, and we should not deprive Europe in general of tools that could promote innovation, because in reality, you know, try to be self-sufficient in everything. Try to do a Google search engine now and try to create cloud providers which will be competitors of AWS and Microsoft, etc. I mean, it's a nonsense. You cannot be, in today's world, you cannot be autonomous in everything. I guess that if Israeli were so good with artificial intelligence till now is because Israeli companies have been able to leverage the tools that AWS or Microsoft or other providers offer them. And this is a whole idea about sovereignty also becomes strategically autonomous, which is that you have to be able to use the best available tools in the market in order to invent the next big thing. And of course, you should do it with all the protections necessary, both at the cybersecurity level and data protection level. But I think this is a very important issue that you raised. And concerning your second question, it was much more, I think it's related to the first one. And it was much more as an observation. I don't have a lot of things to add. And concerning also the issue raised by Tomer, I think it's very important. I entirely agree about the fact that we should not just talk about protection of privacy and of personal data, but this is precisely, I was talking about the Data Governance Act before, this is precisely the idea that, you know, it's about sharing industrial data. Industrial data have huge value, tremendous value, and you should protect this ecosystem. They want to create this health data hub at the European level. You need to protect health data and all kinds of industry data coming from, for instance, car companies in Europe have tremendous amount of data in order to be able. So you definitely need to protect the ecosystem, and this is the whole logic of what is going on right now with these new instruments, the Data Governance Act, etc. So you have at the same time, concerning your what you said also about democracy, Europe sees all this also. For instance, a dimension of the European digital sovereignty that I have not mentioned is the idea that this is also the sovereignty of the user. What we're doing, not only with the GDPR, but also with other instruments, such as the e-privacy directive, we're about now to adopt the e-privacy to transform it to regulation, is the idea of the self-determination of the data user, which precisely is the idea of promoting also democracy through free choices of the individuals. And this idea of protecting the different ecosystems in smart cities, in sharing different kind of industrial and other non-personal data. So this is definitely into the logic of what is going on in Europe.
Thank you very much, Theodore. Well, we've run out of time, but if you want to make a concluding statement on your behalf, you have the right and privilege to do so. It was a very fascinating session, and we appreciate that you did it simultaneously between Jerusalem and The Hague. And we hope that you found the discussion beneficial. And please, if you wish to conclude from your side.
I've talked too much. Just I wanted to thank you very, very warmly for this discussion, which was extremely interesting. I'm surprised to see how many persons attended, and I'm really happy also with the interest on this concept. But I'm very much looking forward to remain in touch. I want to thank you very much, and to be able also to discuss a lot of other cyber or digital issues with you.
Wonderful. So on behalf of everyone, thank you very much, Theodore. And
thank you very much. Have a good one. Bye-bye.
Bye-bye. Take care.